It's Friday, November 9th, and this is Elizabeth Townsend interviewing Michael Hennigan for Dean Massaro's Preparing for Lives in the Law Project. We start with the same question and we end with the same question, and then everything else in between we just make up as we go.
Great.
And it's why did you go to law school, and was it what you expected when you got there?
Well, my answer is going to be different from anybody's because I started law school at the end of my junior year in college. I think predominantly to avoid taking German 3B. In those days, you could matriculate in the law school without actually your undergraduate degree, as long as you had a minimum grade point average. So that semester, when I was here for, let us say, some of the wrong reasons. After that semester, I bailed out, thought it was way too disciplined an environment for me, finished my undergraduate degree, and went off to work for IBM, where I worked for 2 years in Washington, D.C. That's where I discovered why I wanted to go to law school, which was I was working with law firms, I was working with lawyers, and I was an IBM computer salesman, basically selling IBM data processing services. And it was then that I decided that I'd like to work inside. I'd like more of the sort of constant intellectual challenge that I perceived lawyers had as opposed to computer salesmen. And I liked what attracted me also was I thought a little more dignity in being a lawyer than perhaps being a computer salesman. So I came back highly motivated.
And what did you think when you got back?
Well, when I got back to the University of Arizona, I came back in the spring semester 1968. And in the time period that I'd been gone, there had been a revolution occur at this law school, a quiet revolution. But we'd gone from the way things had always been, which was they admitted large classes and expected 2/3 of them to drop out either because they were academically disqualified or didn't really have the interest or aptitude for it, to what I'll call the Ayers years. We were the first class to matriculate under Charles Ayers. So we matriculated with a class of slightly over 100, which was less than half the size of the class that I had left. They had now insisted on things like an LSAT test, which wasn't necessarily required before. They were actually rejecting people who applied to the law school. It was more competitive. The people here were more serious about it. And the young faculty that was in this law school was that had been recruited largely by Charles, along with some of the senior faculty that had been there before. This was an amazing place. Not at all what I'd expected, because I'd had a semester under the old regime. When I came back, most of my professors were not much older than I was. The classes were smaller, the people were more engaged, more, I won't say that they were brighter, but they were better prepared. And this was a place that was a little oasis of stimulating, provocative conversation and study, where the professors were involved in your life. They were your friends. You saw them on and off campus. And I had 2.5 spectacular years here.
How do you think that changes the way you practice law? I mean, if you had done the whole law school thing under the initial regime, do you think your view of law would be different?
No doubt. Every fork you take on the path of life changes the outcome. I think. So I don't know how it would have turned out the first time, without meaning any disrespect at all to the people who preceded me, because I was here accidentally, simply because that's when I got in the mood to come back, without really knowing what was going on here. I would say that beginning then, I at least felt like it was a privilege to be here, that I had I was not only taking the education, I also was assuming some obligations, that I was entering a profession that had high standards, and I had a family of people who I was answerable to. I've always felt that that I had an obligation to the school for what I got here, and that obligation wasn't just to support them in the normal ways that you support your alma mater, but also to make sure that I added dignity to it, that I was worthy of what I'd had received, and that's true even today.
That's pretty amazing. When people talk about, sort of, you talked about like law and dignity, and now there's sort of a sense that like as law becomes more business, that there's less dignity in law, or less sort of all those characteristics you talked about. Do you think they're still here? I mean, do you think that law gets a bad rap, or do you think that that it has become more business? It is more like computer salesman now.
Certainly more business. I mean, when I came out of law school, I think most lawyers who practice privately tended to expect to retire from the firm that they started with. Certainly another revolution started really not long after I was in law school, but a good long while after I was in law school, when they started discussing in the press what lawyers made in the various law firms. That created an environment where lawyers changed firms, where lawyers in the best firms changed firms among each other, where people with the biggest practices made the most money. If a law firm wasn't paying a productive partner enough, they would lose that partner to somebody who would. That partner needed, no matter what level of loyalty he or she felt, that partner needed to be sensitive to how much he or she could pay the people who were working with him on their team, and if he couldn't pay them enough in his existing environment, he needed to consider a move in order to do that. The law became a business. It always sort of was a business, but it wasn't, nobody paid that much attention to it. So, the law practice of today is one where organizations face the constant threat of extinction by the departure of lawyers and based upon their inability to pay them. So you have to price your services correctly. You have to serve the needs of your client in an economic way. You need to constantly be looking at enough premium work so that you can pay your younger people competitive wages. If you can't do it, you lose them.
What's premium work?
In our firm, premium work means work where you can make more than your standard hourly rate. In our case, that usually means contingent fees. But other areas of practice mean, you differentiate yourself so that you can, you've got a unique commodity. Some lawyers these days that are quite high priced are people who are doing energy work. For example, the people who specialize in the energy practice. But it's whatever you can do to convince your client base that you aren't easily comparable to somebody else just on the basis of how much you charge by the hour.
So, so getting back to the other question before we move on to business stuff, so do you think all of this, sort of this push and all of these pressures lessens the law, or does it, is it bad for it to be business oriented, or is it a good thing? Or maybe there's no judgment involved, maybe it's just different. The old timers get, kind of upset about.
I'd be surprised if many of us aren't nostalgic about the times when the economics of practice just happened, and people expected to live a comfortable life but never get rich, as opposed to what we're up against now, which is this. You've always got an economic eye out, or economic finger in the wind. To sort of figure out what's going on, but it hasn't been all bad. Part of it has taken lawyers who would otherwise sort of take things complacently and make them get up earlier in the morning and stay later and work a little harder, and all that is good. I think lawyers tend to burn out, and it's easier to burn out, I think, in terms of your professional quality. It's easier to burn out if burning out doesn't mean diminish your pay. I think in this world, burning out means that you won't make as much money, or if you're running the firm, it may mean that your firm doesn't survive. So you're given fewer choices. So I think what Adam Smith called the invisible hand, I think it's more direct operation in the practice of law has had some positive effects as well in terms of making people work harder, longer, more intensely, with more of an eye toward survival.
And so how does that translate into the culture of the firm, like your firm? How do you see it? Sort of when we get out, what are we getting into when we come to work for you or other firms? Sort of what's going on that we won't necessarily understand when we first get there.
Yeah, when you start off, there's no possible way that you can understand enough to make an intelligent choice, and so things are just going to happen to you randomly. In all probability, you'll either go to the highest bidder, or one of the high bidders, or you'll go someplace that some trusted person or some one person that you liked, and so you'll wind up there, and that's okay too. The random aspects of the way life moves is one of the exciting things about life. But in terms of someone who runs a firm, in my case, a small firm, modest-sized firm, we have about 40 lawyers. We would like to create an environment where you're excited by your work, where we don't, in my firm, we don't have a minimum number of hours that lawyers have to work, but we look at low output as a symptom that we're not doing things well. That if we are doing our job well, then you will be driven to the kind of productivity internally. You'll have an internal drive to achieve it, because the competition will be good, the job will be interesting, and there's always something else to do before the deadline. There's always something that needs to be done that isn't done before the deadline. So we need to do that, and we need to pay you well. If you come out of law school to our firm and we train you and you develop the kinds of skills that we hope you will develop, and then you hit the mark, then you're a marketable commodity. I suspect that the lawyers in our firm get, I don't know, they don't call me and tell me each time, but I would guess they get a call a week from a headhunter they're constantly trolling. They're all constantly wandering around the edge of the herd, trying to pluck people off for their fees. That's another one of the economic forces that's happened in the law, and that's the profession of headhunting, or we should say the economics of headhunting. So I know every day that the younger lawyers in my firm are going to constantly be called by headhunters, making them offers, enticing them to move. And so I need to pay you well, but I also need to create an environment where you're not anxious to receive that call. So.
All right, I have some questions. What is low output? What does that mean? Because we hear so much about billable hours and minimums and all those sorts of things, and what you're saying is very different from, it's at least the words you're using are different, but what exactly do you mean by low output? Is it still sort of, I'm not sure.
I tell the young lawyers in our firm that we don't compensate based on hours, and that's true. We're aware of hours, and we use hours as a measuring rod to say, are you efficient? Are you working happily? If in our firm, I assume that every law student now understands what a billable year looks like. When I came out of law school, we didn't know those things. When I first started the private practice of law, we kept time records, but I never got a report as to how many I billed. I didn't know, and we don't report to our lawyers what they bill. I think most of them know. I think most of them keep their own records, because most of them sort of understand that 1,700 is not enough, and 2,500 is too many, and they ought to be in there someplace, and I think that's probably right. You ought to be in there someplace. Mm-hmm. If you're active, alert, intelligent, doing the job well, growing in the practice, having people, involve you in their cases, there will be enough work for you to do 2,500 hours. If people in our firm do 2,500 hours, I'm usually sitting down with them saying, get a life. That you won't be the best lawyer you can be if you're here 7 days a week. You won't be the best lawyer you can be if you are working until 10 o'clock at night. If you've got a family, go give them a hug. If you've got activities, go do them. If you don't have activities, go get some. Lawyers we function in a community. We need to be aware of our surroundings. We need to know people outside the office. We need to, when we hear of current events in our communities, we need to know what that means and who's who. And so get out, go, make a difference. Go get involved in a charity or something like that. We don't need it from you. We don't want it from you. We don't want bloodshot eyes and the kind of. Lots of people have been given credit for this phrase, and I don't know who said it, whether it was Winston Churchill or Abraham Lincoln, but who said, I can do a year's work in 10 months, but not in 12. It's true. You need time to yourself. You need time to reflect. You need empty time to be an effective lawyer.
Did you always feel that way?
No. I thought when I first started, particularly when I first started my own practice, I worked 7 days, and not all day 7 days, but 7 days, and felt like I couldn't not do that. That the demands of the work were such that I had to keep at it. And then my kids started to get a little older, and I thought, gee, I'm going to miss the whole thing unless I take weekends off. So I started taking weekends off just for that reason, and I discovered, hey, I'm getting more done, not less done. I'm coming back with better ideas on Monday than I had on Friday when I left. As opposed to the 7-day work week, I always just did the same job. I never stopped to reconsider it.
So do you think there's a culture that's trying to start from the very beginning doing that? That your generation saying, maybe we should do things differently from the beginning, that you're a young lawyer, don't be here 7 days a week, or is that not?
That's our firm. I get the strong sense that the larger firms, the ones that that are more aware of the economics, one of the things that I'm really disappointed to see is some of the firms giving precise benchmarks that you get this kind of a bonus if you do 2,000 hours, you get a bigger bonus if you do 2,100, you get our biggest bonus if you do 2,300 or something like that. That confuses the practice of law in my mind, that our job is not to fill out a timesheet. Our job is not, the client doesn't care how many hours you have. The client does care how many hours you have. The client would like you to have fewer hours. The client wants a result. The client wants an efficient result. And if your lawyers are sitting around trying to figure out how they're going to get to 2,200 hours or 2,300 hours, I do not believe that we're doing a service. And we're not doing that as a service to our clients. And we have steadfastly resisted it. And I've actually given people smaller bonuses who had too many hours as a little signal to say, this isn't what it's about. It's about efficiency. Ideas win lawsuits, not piles of interrogatories.
On that efficiency note, there's also sort of some people are writing about technology that in some way people saying technology is going to make you faster, bigger, stronger, you can do more. But then the other side of that is people say, well, then you could just bill more hours. There isn't a sort of decrease in work. It's just like a way to get more work in. I don't know what you think about that. That sort of, research should take a shorter time. I mean, theoretically.
Research does take a shorter period of time. I mean, I could waste all of your time telling you how we used to shepherdize cases. It used to take you hours and hours to shepherdize a brief. You can do it in minutes now. So there's no doubt that the process of legal research is much more efficient now. Your ability to access vast amounts of information is better. Your ability to turn documents around is better. All that's better. But there's always more work to do than can be done if you're a busy, successful practice. So when I first started in private practice, an older lawyer, a guy at Snell and Wilmer named Roger Perry, came into my office one day and said, a lot of young lawyers think you need to be producing a piece of paper in order to have it be billable. He said, it's not what the client pays us for. The client pays us for our ideas and our solutions to problems. And that frequently comes when you're just staring out the window, when you're just deep in your own thoughts. He said, don't be afraid to have that be an important part of your day. That's what wins lawsuits. I think every lawyer who's ever worked for me has heard that from me now that I heard from him. And it's true. We tend to get absorbed in work and performing the task and in taking a deposition because we take depositions without really sitting back and saying, why am I taking a deposition, and what exactly is my theme and thesis for the case, and am I building it, or am I simply just curiously finding out what this guy knows about the case, and is that the right thing to do?
So with that then, how do you, when you first start out, okay, so you have a new case and you're thinking about it and you're doing the sort of preliminary research, are you ever afraid, do you do extra research in case your thesis changes, or, I mean, how do you sort of, you're thinking, and I mean, it seems like, do you know what I mean, like, I mean, not that ideas and thinking isn't good, I mean, it's fabulous, but the other question is, how do you make sure that you don't go down one path without leaving yourself, do you know what I mean, like, how do you, as a young lawyer, sort of, because you don't know anything, really, you know?
Someone once described to me the difference between a trial lawyer and a litigator as being two people get up in the morning to go fishing, and both stop at this one farmhouse and ask where they can find worms. And the farmer says that worms are normally on the north side of the field where it's moist, you know, under the rocks in the shade. Mm-hmm. And the trial lawyer goes to that part of the field, uncovers the moist rocks, gets enough worms, and goes fishing. The litigator starts on the other end of the field to make sure that the advice has been correct and uncovers all the rocks. And I guess part of what that metaphor means for me is that there are risks involved in being a lawyer, and sometimes the decisions you make involve risk. You have a risk every time you adopt a thesis for a case. It might not sell, it might not be true, the evidence might not back you up. What we do in our firm, which is a little bit different, I think, is we spend a lot of time on the development of theme, on the development of thesis. We seminar cases. We get senior lawyers and junior lawyers and sometimes paralegals in a room repeatedly, and we talk about what the case is about and how it looks to us and what the theme ought to be. And then we do that as we begin to build it. You know, we keep talking about it. Is it happening? Are the witnesses supporting the theme? Do the documents help us or hurt us? And so we're constantly sort of adjusting the theme to conform to the evolving sense of truth as we see it. But we're always on a theme, or we're always fixing the theme. We're very rarely, I think, sitting around saying, let's examine all the possible themes. I mean, I guess we do that implicitly, but mostly we're always trying to narrow.
Can you give me an example of a theme?
We do complex. My firm does complex business litigation. So I think when I started law school here, my first tort professor was Professor Robert Emmett Clark, and on the first day of torts, he may have done what every first day tort professor does, and says, "What's a tort? Right? What does it mean?" And I remember he said, anyone can understand a punch in the nose. I would say, we don't deal with punches in noses. We deal with conceptual torts. We deal with theoretical torts. We deal mostly with things like fraud and breach of fiduciary duty and things like that. So we believe that, it's been our experience that sometimes it's just the way you say it that makes the difference between winning and losing. Sometimes you can take the same set of facts and describe them one particular way, and it makes perfect sense, and it all lays down in line, and you say it a slightly different way, describing the same configuration of facts, and it doesn't make any sense, and it can't sell. So I'm not sure how well I can do a particular example, but one that comes to me is a couple of years ago, I was responsible for trying to recover for Orange County, California, about $1 billion that they had lost speculating in the bond market, basically. And our problem was that you typically take on a securities case like that, and it's most conventionally viewed as to whether or not there had been deception and whether there had been overreaching in terms of the description of risk. What we found was that at every responsible level of Orange County government, people were aware of the risk. In fact, there had been an election against the incumbent treasurer in which the risk of the portfolio was the subject of election, and the treasurer had been reelected. So one of the things the defendants were arguing was not only was the risk fully disclosed, which we had to concede it was, but that the voters had in effect voted to take the risk, which they sort of had. I mean, you had to get into it to say, well, how much do voters really understand, and who really understands the risk until they've suffered a loss? But we were confronted with the absence of a conventional thesis, and so we needed to develop a theme that could sell in the absence of what we call a conventional way of looking at it. So our principal opponent was Merrill Lynch. What we decided to do instead was to focus on what Merrill Lynch had earned in the process. And it turned out that the salesman who was working with Orange County was the highest producing salesman that had ever existed in Merrill Lynch. He was the highest paid person at Merrill Lynch outside the top executives. And that this was the most profitable account that Merrill Lynch had ever had. And so what we proceeded with instead of fraud was the overcharging that was implicitly occurring by Merrill Lynch in the structuring of the types of securities that they were selling us. And we kept hammering the table and saying, where was there any justification for that structure? It was a deceptive act to have concealed their compensation, and it ultimately prevailed. But so I won't tell you about all the ones that didn't.
You can tell me about one that didn't. Dean Massaro likes the ones that fail. That's her big question of like mistakes. Maybe we could do a mistake. Things that you learned from, like, because it's the stories that are good are they make you feel good, but they're not as easy to learn from. I mean,
and you talk to trial lawyers, and I suspect that most trial lawyers can tell you almost every question, answer, and witness in the cases they lost, and the wins blend together. But my own experience was I came out of law school, obviously well-trained, energetic, and very, very fortunate. I never lost a major motion for my first 3 years in practice. I thought that people who lost cases were just not as smart as I was, or not as well-trained, or didn't work as hard, or something. I mean, it wasn't me. And the first case I lost, looking back on it, I didn't see it coming. It was a jury case. I'm trying the case to the jury as I began to see the jurors, sort of turn away from me. I would just start talking to the jurors who were still with me. So instead of talking to my problems, I was talking to the people who were already supporting me. I was dangerous. I gave very bad advice to my client that day, in the sense that we had a settlement opportunity while the jury was deliberating that would have made a difference in his life. I said the things I should have said to him about risk, but my body language was no doubt telling him we're in good shape here. Jury came in 9-3 against me, and I was devastated, but I learned today. I talked to the jurors who are against me. Today, I know that it can happen. I know that it's not always just me. That I can that I'm going to encounter people who aren't going to agree with the way I'm phrasing the case, and I need to deal with it. I need to look at it straight ahead.
That's pretty cool. What about the client? Do you feel like overly responsible when bad things happen, and how do you cope with when things don't go the way you think they're going to go, or a client is upset about how they go? What do you do, and do you take that home with you, or how do you get over sort of feeling bad about things?
I was being interviewed by a prospective client about a year ago, and he wanted to know about track record. And I said, well, I win, overwhelmingly the majority of my cases, but any trial lawyer you talk to who's my age will tell you the same thing. He said, how can that be? How can you all win most of your cases? I said, because people who don't get out of the business. Because the wins do not overcome the losses. That the losses are much more devastating than the wins are positive. And so, I don't see how anybody could do it in terms of if you lost 4 or 5 in a row. I don't see how you come back to court. And, maybe you can, but so much of what happens in my world is based upon attitude. The difference between winning and losing is you could take a transcript of a great argument, a Clarence Darrow argument, or some legendary argument, and I guarantee you, give it word for word to 3 different people, it'll have 3 different outcomes. It'll sound different. And in my case, I believe that the difference between success and failure is more often than not just the attitude that I bring to the process. Hopefully the theme and the thesis is right. Mm-hmm. Hopefully the words are there when you need them the most. But if I walk into a courtroom feeling like I'm probably going to lose, I lose, I think. If I walk in feeling, I have to walk in feeling entitled to win. I have to walk in feeling deep in my soul that the presentation I'm making is just and fair and the result I'm asking for is deserved. And if I can't do that, I can't do it.
That's really interesting. I have a couple of questions about that, because you're telling a story. It's basically, it's all about, I think about fiction. It's narrative. You keep using, plot, thesis, narrative, attitude. Different people tell different stories. That's pretty remarkable. Do you think that's a good thing with the system? And also, what happens when you don't, how do you get to that space? And if you don't feel like that space, then what do you panic? If you think your story isn't going to be, if you know you've got to feel that way going in, and yet you don't feel that way, what do you do then?
I've never had that experience.
You haven't? because of all the things that you do to get prepared for it, so that you feel like
we, and ours is a collaborative effort. We work ourselves into what we call the high ground. We find the way. If you can't find the thesis, which I can't ever remember having not been able to find, but if you couldn't find it, you tell your client that we can't win this case. That this case, you can certainly hypothesize circumstances, but normally when cases get fought at that level, there is something to be said on both sides. And you have to find what it is to say on your side, and you have to, work it and shape it and find the policy behind it and the emotion and the story behind it and the human side of it. I'll tell you another thesis story. One that comes to mind is I had a case involving a huge fraud, we thought, involving the reconfiguration of several 747 aircraft. Big case. Going to be high tens of millions of dollars worth of damages. And one of my young partners put on a mock trial, a focus group, so that I could watch to see how our then thesis was playing. And I watched it, and we'd worked it up in the conference room, and I thought it was okay. And it was a big finance company against a big airline. We represented the airline. And I watched that thesis develop in front of the mock jurors. Mm-hmm. And as he was describing it, the way we described it in the conference room, but when he's standing up and describing it to this group of people, I said, this can't sell. This can't sell. You can't commit fraud, or nobody will ever find fraud in a case between two corporations. It needs to be about people. So I walked out of there, and we went to trial. It was about people. Yeah. When I stood up in front of the jury, I had the chairman of the board of my client sitting in front of me. He's sort of a gruff guy who built the company up with his bare hands. And I put my hands on his shoulders and said, "Ladies and gentlemen, this is Del Smith. He built this airline. I'm proud to represent him." And from that moment on, I never talked about the company. I talked about Del Smith. I talked about how this man sat in a room and was lied to. How this man was entitled to more than he got out of the transaction, and it wasn't a problem. But I don't think I could have done it if I'd said it different. I don't think I could have said Evergreen International Airlines and gotten the same result. So sometimes it's just
It's really interesting.
who I'm looking at.
Now, since you're telling this to second and third year students who will like this idea, how does like the law play within your narrative? I mean, you can't
The law.
like the yeah, like the sort of the whatever, all the stuff we're learning at school. How does that fit within your narrative? I mean, can you tweak it? Can you not? Can you? I mean, how far can you go? And is that something that students should worry about or think about? Like, because you know that people will think like yes, and then they'll go way in one direction with this. So I want to make sure that we get that part in too.
When I graduated from law school, I thought I could solve every problem in the library. I thought, give me a fact situation and I will come out with the answer. I don't want to say that the library is the last place I go now, but I think among skilled lawyers who have a strong sense of where the law is, that themed building is always got it. Our guideposts are reported decisions. But I think it was Aaron Burr who once said that the law is that which is forcefully stated and plausibly maintained. Law is driven by the facts. The right factual scenario, the right presentation, the right policy that drives those facts will create the law. If you can persuade the judge and the jury that your cause is just and deserving of relief, there'll be a case that supports you, and they'll follow it. Conversely, if you're on the wrong side of it, it's going to take a very authoritative decision exactly on point, which almost never exists, to defeat you. So, weak cases get strong with strong facts, and strong cases get weak with weak facts, even if the statutory or decisional law would appear to be different. So, it's part of the feeling of it. The fabric of it is human. I mean, one of the things that shocks, I think, particularly good law students when they come out, is how subjective the law can be, how subjective it is, and how a powerful case speaks, cries for equity in one forum, and you say the same words the same way in a different one, it comes out different, because the judge is different, because the community is different, because the jurors who sit in the box are different. Did you follow the O.J. Simpson case? Mm-hmm. There wasn't that much difference in the facts in the two trials. Mm-hmm. One jury saw it clearly one way. Mm-hmm. One jury saw it clearly another way. Mm-hmm. Right. Different part of town.
Right. And a different time in, don't you think? I mean,
I think it's a different part of town. Yeah. I think it's the ethnic, cultural composition of those two juries made it completely predictable how it was going to turn out each time. In one group saw the police as their enemy, as people who they knew from their own experience would fabricate evidence, would create situations that would lie under oath. The other group saw the police as their friends, who protected them, who were trustworthy. Johnny Cochran couldn't have won the second trial. Bob Baker couldn't have lost the first.
Very interesting.
In my view.
Before we run out of time, we're going to do short, fast questions.
Okay.
No, we're not doing. I almost thought it was quarter till, and it wasn't. I was really excited that we didn't have as much time as I hoped. It was a sad moment. Okay. Your least favorite part of practicing law, the thing you hate the most. It could be a little tiny thing, it could be a big thing. Doesn't have to be now, it could have been in the past too.
I don't like timesheets, but we live with them. One of the, I've been part of a very large law firm and have my own firm that's smaller than that, and when we recreated ourselves out of the very large law firm, I decided at that point that I wanted to keep my size below what I call committee level. So we have no committees. We resolve firm issues in the hallways and over lunch, and we don't have a lot of people running around, being firm managers. So we're probably not terribly well run, but I don't like the committee approach to the practice of law that occurs over a certain size.
Why?
It's inefficient. Lawyers, tend to get involved in what I call running for student body office and justifying their activities on committees as opposed to what we're supposed to be doing for our clients, which is crafting effective and efficient results for them.
Do you have like a managing partner that deals with all the managing partner stuff, or do just people take different parts of it?
Different people take different parts of it. We have somebody who has the title managing partner. He would laugh if he were here, listening to me describe him as really a managing partner. We manage very lightly.
Okay. Your favorite client. Like, why would be your, and why? Like, what makes a good client, and why were they your favorite client?
Well, we have a different kind of a practice than that. We really don't have long-run clients. We're a referral firm. We basically do very large cases. Clients generally, we've had a few clients that were represented more than once, but generally speaking, the cases we deal with are so large that it's very unlikely that anyone would ever have two cases of that magnitude again. So my favorite clients are really more like what's going on now, and so I've got a real estate developer who I enjoy very much working with, but he's an active client. I certainly enjoyed working on that 747 case that I described earlier, and anytime you go to trial with somebody, you wind up. Oliver Wendell Holmes, once described in the Civil War, after he'd been in it, he said, "We have shared the incommunicable experience of war." Well, we use that war metaphor. Obviously, it's overused, but trials are like that. Trials are experiences that bring vividly all aspects of your range of human emotions, and sharing it with somebody is always a special experience.
How close can you get to clients? Do you feel like there's always has to be a professional relationship, or do you become good friends with them, or is that dangerous?
There needs to be a professional distance. You need to be able to tell the client, when they're in trouble or when what they're doing is unwise. But at least in my experience, I need to have a close enough personal relationship so that I could never fool a jury that I like and respect somebody that I don't. So we get pretty close to the clients.
We started with sort of your thoughts about your feelings on this law school once you left, and your obligations and things like that. I thought maybe particularly sort of for second and third year students who haven't been out yet, maybe we could go back to that a little bit in terms of maybe giving them ways to think about law school when they get out, and sort of, do you know what I mean? Like, it was very moving what you said, and I think that maybe they could benefit more from talking about that a little bit more.
Well, what we receive here is a gift. It's easy to think, because it's competitive to get in, and because law schools vie for top students, and top students vie for law schools, that there's a sense of entitlement about being here if you are here. But the truth is that what you receive here is something that began a long time ago and built 1 year and one professor and one student at a time over a long period of time. And I think it's a mistake for us not to realize that we both have received this gift, and for most of us there ought to be some sense of obligation that goes along with it, and not just the obligation to give back monetarily, but the obligation to understand, particularly those of us who aren't in Arizona. I practice in Los Angeles, to say that people will look at you and say, where did he go to law school? And every time they look it up, they will in part judge the law school by what they see in you. And if you're competent and honest and do your job effectively and well and distinguish yourself, you'll be distinguishing the school as well and the profession, and all those things are important.
That's really cool. We had someone else talk about they didn't use the sort of young associates that get sort of picked off by the people as sort of creating a market commodity, but they talked about how they personally felt terrible when they would train someone and then they would leave, and that there was very they felt sort of not betrayal but just depressed, and then it was very hard for them to sort of deal with that. And you seem to have a very different view of, a much more sort of, there was a more realistic view of sort of the way the world is, but I thought maybe we'd just touch on that again, to see what you thought about that and your relationship and how the relationship maybe changes in that, in terms of this economy that we live in at this point.
Well, we've gratefully not experienced the need to contract. Law firms are contracting right now,
Mm-hmm.
Particularly the people with large transactional practices, but getting away from the world where there's a contraction in the law. Since I've been practicing, it's been mostly growing. The biggest firms in the country when I was coming out of law school were 100 lawyers. Now there are 1,200 lawyers, 1,300 lawyer firms, and my view of it is all those people want each of my associates, and if I'm going to keep them, it's going to be because I do my job well, which is, what's my job? My job is to deliver a constant diet of interesting, provocative work, to create a law firm that they're proud to be part of, that they can tell their friends and associates when they say the firm name that they get a little positive feedback, and I've got to pay them well. And if I fall down in any of those three categories, I'm going to have those disappointing experiences where people go off and go to other firms. So that's my job.
Marketing. We'll have to do this really fast because we're now getting into bigger questions. We're supposed to be on the short questions, but we haven't touched marketing. Thoughts about marketing? Do you do marketing? Do you word of mouth, reputation? Do you think marketing is important?
I'm sure it is. We've never gotten around to it. It's not because we didn't think we should. For example, we're highly technologically advanced. We've got document management systems and in-court presentation capabilities, and we do all of our own graphics inside our own firm, and we've got Blackberries and emails and all the things that you'd have. We don't have a website. We intended to have one. We just haven't quite gotten around to deciding what it ought to say. We don't have a firm brochure. A prospective client asked me this morning if I would send them, please, the write-up about the firm. Well, we've never quite finished it. So I had to refer them to Martindale and Hubble, which was the best I could do. So, yeah, we see it, but it's not part of our lives.
But it's obviously not hurting. You're not obsessed with that. So obviously
We've been very fortunate. We've been very fortunate. We're a referral-based firm. My cases mostly come from referrals from other lawyers, and I also have my second name partner in my firm, Bruce Bennett, is, in my humble opinion, the brightest, most capable bankruptcy lawyer in the United States. I realize this may be, somebody may look at this 100 years from now, but we're having a difficult economic time right now. It sort of rains business on us in difficult economic times. So.
What does that mean for your young associates? The whole rainmaking thing and trying to get clients, is that not something that they have to worry about, or do you think everyone has to worry about bringing business in, even if you're a referral, even if you get a lot of referrals from places?
In our firm, we do not encourage anyone to bring in business. It's simply because we're highly specialized and the odds of somebody bringing in a young partner or associate bringing in a case that we would actually do is small. We discourage it, but in terms of young lawyers, finding their way, my son-in-law is a lawyer. I've been explaining to him that if you want to break out of simply being a commodity, if you want to or a replaceable entity, somebody with skill who can do this job for this firm or that firm or the other firm, you're going to have to get your own clients. You're going to have to figure out how you do that. Maybe you have to figure it out. I'm not sure that anybody actually figures out how you do that. But that, from my perspective, that means being involved in the community, being involved in the bar association, getting around, getting to know people. People hire lawyers they know.
Can we do one more question?
Mm-hmm.
Okay. All right. Yeah. Your family. Do they love the law? Do they hate the law? Do they have an antagonistic relation? Do they understand? Like, is it different when you're in trial or not in trial? Sort of, how do you balance your life with them? Sort of, we had lots of people talk about balancing life, but I'm just curious how you feel your family feels about sort of the law. Do you know what I mean? Like,
let me put it this way. I've got two very bright, very capable daughters, neither one of whom was attracted to the law. I think my oldest daughter, who set off in college to be a lawyer but changed her mind very quickly, explained it to me this way. She said, "Dad, you were a great dad, but you would have been a terrible mother." And we have a little slogan that's actually hanging on a wall in our house that says, "It doesn't cost any more not to go." And what that means is all the vacations that we canceled, all the prepaid deposits that we forfeited, because some judge somewhere told me that I had to be someplace instead of there. There is no doubt that to do this well, like anything, it takes a commitment. But I also think if you're going to do it well, you need to balance your life, and you need to put your family as a priority. It needs to be your first priority. It can't always be the most immediate priority. There are going to be disappointments. There are going to be, my life was littered with missed birthday parties and missed vacations and things like that. But I think partly from the tenacity of my wife, who insisted that the family always be a priority. It always was. And I don't think you can really succeed in one aspect of your life and not in others. I think you need to balance.
And you talked about if people work too much in your firm, then you tell them they need to get a life. Like, does that mean that the firm sort of supports people when they need to go to parent-teacher conferences or birthday parties or things like that? I mean, do you try as much? I mean, obviously you can't do it all the time because as you said, there are pressures that you can't. But like, how as a firm can you help encourage that?
You create an environment where people know that that we expect that to be their priority, and we understand, that there are things that are more important than what we're doing, whatever it is we're doing. If it happens over and over and over and over again, you sit down and say, are we a high enough priority? Mm-hmm. But generally speaking, we have people who are part-time partners in our firm, a single mom who came in and said her priority was to raise her son, and she needed to have both a flexible schedule, and in some years she'd work 800 hours, and some years she might work 1,200, but would we understand that? We said, we do. Fine. And she's demonstrated over time that she understands the priorities, and when we are truly a priority, she's there.
Would you do that with a lower level person, or
Yes.
do you think, yeah?
Yes.
Yeah.
Right.
That's pretty cool. That means a lot, because I think there's so many people that law school isn't just young people going anymore. So when people get out, they may care deeply about what they're doing, but also have those pressures that make it impossible to meet those high billable hours.
It's like nails on a blackboard to hear people talk about high billable hours. I mean, it's the thing that if there's one thing that has annoyed me more than anything else about what's happening right now, it's the big good firms, or firms that used to have an excellent sound to them, are pushing their people to have billable hours. And to me, when you create that environment, your associates will come in and try to figure out how to fill up their timesheet instead of sit down and try to decide what's the best thing to do for the client today. And, you know, but I guess it's the world we live in.
All right, we have to do our last question or we're getting in trouble for making you late. Okay, happiest moment. What is like one, it can be in one moment, it can be a type of thing, or many happy moments, like in law, your life in the law.
Any trial lawyer will tell you about the satisfaction that occurs when a jury comes back and sees things your way. And if I would trip back through my life, I can put myself sitting in the longest moment in a trial lawyer's life is the moment from the time they announce they have a verdict until the time you hear what it is. Even if you're in the courthouse and it's only a few minutes, those are dilated periods of time and very intense. But there are. Actually, I'll share. This is not original. It's just something that was memorable to me. Years ago, an old trial lawyer told me that there are really only 4 things about being a trial lawyer that are fun, and one of them is a just result for a deserving client. Another is a devastating cross-examination where you feel like you just won the case that moment. The third is a final argument where you feel like you're in a mind lock with the jury and you and they are just of one mind. And the fourth is talking about trial law with other trial lawyers. And all the rest of it's just work. It's not far from the truth. But those 4 things that happen with enough regularity to keep you at it can make this a pretty fun way to live your life.
Any other thoughts or comments before we end?
No.
Thank you so much. This
Sure.
was great. This is really great. Thank you.